Thank you, Mrs. Sakorafa, for this important opportunity. I think without a shadow of doubt, this is a momentous occasion in Europe, I think, given that this is supposed to be the bastion of democracy in the world. I'm also happy to see my colleagues on the Truth Committee on Public Debt, the former Speaker of Parliament, Zoe, Eric, and the others. It's a pleasure to see you again. I'm going to speak about the UN debt restructuring mechanism, the state of play. Let me begin by saying that even the most skeptical of us...
Former UN independent expert on foreign debt and human rights, he visited Greece for the first time in 2013 in order to assess the impact of the memorandum on human rights. And in his report, he said that our country's creditors shouldn't just be focusing on figures and statistics, and said that Greece should carry out a debt audit. Mr. Lumina, I'm sorry once again.
Thank you, Mrs. Sakorafa, for this important opportunity. I think without a shadow of doubt, this is a momentous occasion in Europe, I think, given that this is supposed to be the bastion of democracy in the world. I'm also happy to see my colleagues on the Truth Committee on Public Debt, the former Speaker of Parliament, Zoe, Eric, and the others. It's a pleasure to see you again. I'm going to speak about the UN debt restructuring mechanism, the state of play. Let me begin by saying that even the most skeptical of us concede that there are occasions when sovereign states experience difficulties in meeting their debt repayment obligations. What is less certain, or where there is less agreement, is what should actually be done to address those particular difficulties. But for me, I think it's a matter of common sense that when a state experiences such problems, ways must be found to address those problems. And typically this requires that we must look at the debt repayment terms, including making them flexible for the country concerned, or in extreme cases, cancelling the debt altogether. Now, however strong the presumed contractual moral obligation to repay a debt in full, I think it is simply impossible for a state to do so in some cases, and it's therefore important that there is some way of restructuring sovereign debts, and that such a process should be independent of the views of creditors as to what the debtor state deserves in the particular situation. But more importantly, such processes should take cognizance of the devastating consequences of debt crisis on the populations of the countries concerned. And in this context, I want to mention the United Nations Guiding Principles on Foreign Debt and Human Rights, which were endorsed by the Human Rights Council in 2012, and which I had the privilege of writing during my 6-year tenure as UN independent expert. Paragraph 56 of the Guiding Principles make it very clear that the obligation of debtor states to repay under a valid and legitimate external debt agreement must be honoured. Nevertheless, there are circumstances rendering the debt unpayable, such as severe debt, financial distress of the borrower, and natural disasters, which may warrant changes in the reciprocal obligations between a debtor state and its creditors. And so the guiding principles go on to underscore the importance of establishing at a global level an independent mechanism for the restructuring of sovereign debt. And the principles also make clear that the establishment and operation of such a mechanism should be guided not only by human rights, but by the following principles as well. First, it should be independent of creditors and debtors, unlike the current ad hoc systems that we have in place. Secondly, the assessment of the debtor state's economic or financial situation should be made by a neutral body. Third, the mechanism should ensure that a debtor state during and after the restructuring process is able to fulfill its human rights obligations and, importantly, to provide basic services to people under its jurisdiction. Fourth, it should have the mandate to determine the alleged odiousness or illegitimacy of particular external debts. And the other point I want to make is that these particular issues that are mentioned are not new inventions. They are merely a reiteration of what exists at the national level. I think we all live in jurisdictions where there are national insolvency laws that protect not only individuals but sub-sovereign entities that find themselves in debt repayment difficulties. Since the 1990s, several proposals have been made by various stakeholders for an international mechanism for the orderly restructuring of sovereign debt, but none of these proposals has ever been implemented. So expectations were very high when, on the 9th of September 2014, the United Nations General Assembly adopted a landmark resolution 68/304 and established an ad hoc committee to develop a multilateral legal framework for sovereign debt restructuring. This initiative was driven by the Group of 77 and China. But as we shall see, as I continue to speak, these hopes seemed to have been somewhat premature, and they were completely dashed in some way just a mere year later. The General Assembly's ad hoc committee faced a key challenge in discharging its mandate. Virtually all developed countries, including the whole European Union and the US, refused to participate in the sessions of the committee. And this was a rather disappointing turn of events, particularly given that UN processes are inclusive and tend to be transparent, which is not the case in other platforms where sovereign debt issues are discussed, namely the IMF and the Paris Club. While the IMF and Paris Club negotiations take place behind closed doors and there are no minutes of their, the minutes of their meetings are not published, the UN ad hoc committee negotiations were fully inclusive, involved multi-stakeholder participation, and all the sessions were broadcast live for the entire world to see. But as a result of the boycott, the G77 made a concession to adopt basic principles on sovereign debt restructuring processes instead of the original multilateral legal framework that was envisaged. Nevertheless, this concession did not satisfy those countries that were opposed to the idea of the UN playing a key role in relation to sovereign debt issues. On the 10th of September 2015, the General Assembly voted to adopt a set of 9 basic principles, and my colleague Maria Lucia has already mentioned them, so I will not repeat them. But what I want to underscore here, which is worrying as we look at this problem, is that the vote was split along developed and developing country lines, with 136 votes in favor, 6 against, and 41 abstentions. The 6 countries that voted against, and this is a matter of public record, were the United States, Germany, the United Kingdom, Japan, Canada, and Israel. Perhaps the vote is not entirely surprising, because this particular voting pattern is actually the pattern that has been characteristic of the issue or discussions on sovereign debt within the United Nations, where developing countries frequently vote in favor of measures to enhance the stability and fairness of the global financial system, while the most powerful countries often block such measures on the questionable grounds that the UN was not the appropriate forum to address such issues. And I can categorically say that this is a totally misguided notion. I think that the UN has sufficient global legitimacy. It might do certain things in a way that we're not happy, but I think it's the only inclusive forum, and therefore a forum with sufficient global legitimacy to handle this particular problem. In explaining its vote against the resolution, the US delegation said that the General Assembly resolution had several flaws, including the fact that or the claim that it implied that there was a right of a state to restructure its debt and that there was the principles posed a threat to contractual obligations. In the view of the U.S. delegation, a statutory mechanism for debt restructurings would create uncertainty in financial markets. And I want to quote what the U.S. delegation says. Quote, "The proposed basic principles on sovereign debt restructuring processes are problematic in several respects, including language that could be construed as acknowledging a certain right to restructure sovereign debt which does not exist. The principles could also undermine the enforcement of contractual claims. These and other concerns highlight the United States' view that the United Nations is not best placed to address the issue of sovereign debt restructuring," close quote. In a similar vein, the European Union argued that the text of the GA resolution contained a number of statements that were not an accurate reflection of existing international law or treaties. And the EU delegation expressed reservations that the resolution did not adequately support the preferred creditor status of the international financial institutions or the decisions of competent courts. It also made the point that the IMF is the appropriate institution to host global discussions on the subject. Now, interestingly, Greece, which we all know is drowning under the burden of external debt, abstained from voting, as did all other EU countries, with the exception of the UK, which voted against. But this is hardly surprising, given that the EU had, in effect, prescribed the position that its members should adopt during the vote, despite the fact that some of its members would undoubtedly benefit from such measures. And in this regard, it's interesting to note that there are 6 European countries whose public debts are larger than their economic output, and 16 that have debts larger than the threshold set by the Maastricht Treaty. On the 7th of September 2015, 3 days before the General Assembly was due to vote on the resolution concerning the basic principles, the European Union issued a document. This is document number 11705/15, indicating its common position on the UN draft resolution A/69/L.84 on basic principles on sovereign debt restructuring processes. And the document emphasized, and I quote, "A split vote would undermine the efforts undertaken so far to establish and maintain a common position on this very sensitive file or issue, which is of major importance for the EU itself, ever more so in the current context, and that it is important that member states enter into and follow through on a common position in respect of the IMF and UN context, and that this position is the basis for internal and external coordination," close quote. I believe that the position adopted by the developed countries, including the EU as a whole, is fundamentally flawed for the following reasons. First, it fails to recognize that the United Nations has 3 core purposes: the promotion of human rights, promotion of development at a global level, the promotion of international peace and security. Sovereign debt is not only a human rights issue, but also a development issue, and so the UN is competent to deal with the subject. Secondly, the IMF and the Paris Club record in addressing debt problems is not very inspiring. As I mentioned, everything happens behind closed doors, and we all know there is sufficient evidence. Greece is only the latest in a whole line of failures of IMF programs around the world. Third, the IMF and the Paris Club do not have the requisite expertise to properly factor human rights into their policies and programs. In the case of the Paris Club, it doesn't even exist as an international organization. So what legitimacy does it have to deal with this particular problem? Fourth, the position of the EU is completely at odds with any accepted notion of democracy. And I begin by saying that this particular conference was being held in the bastion of democracy. But look at the position that the EU prescribed for its member states, completely at odds with what the EU preaches to other countries. I would like to conclude with two points and a question. The first point is that there is some uncertainty about the future of the UN Sovereign Debt Restructuring Initiative, and no one seems to know within the UN or even at the General Assembly in which direction we should be heading or how exactly the basic principles will assist those countries that urgently need to have their debt repayment difficulties addressed in a fair, transparent, and enduring fashion. But I think it is fair to say that the principles serve as a basis for future work on sovereign debt restructuring processes, as Diego mentioned. Secondly, I share the view that the principles on debt restructuring, that is the UN principles, provide the basis for a fair, balanced, and effective process for sovereign debt restructuring through a universal legal mechanism that is supported by the only organization with global legitimacy, the United Nations. Let me leave you with the following question to reflect upon. Does the so-called EU common position really reflect the wishes and demands for social and economic justice of the ordinary people of Greece and other EU countries, those that continue to suffer from the burden of sovereign debt and related adjustment? Thank you.
Thank you very much, Professor Lumina. We have 7 speakers on our list who would like to take the floor, ask questions, and make comments. Please don't take more than 1 minute so we can go through everyone. I'd like to tell you that in the European Parliament, often you only have 1 minute to make a speech, so get everything you can in that 1 minute. I'm very sorry that we can't give you more speaking time. Garden from the Economic Department of the United